So let's talk about costs and let's talk about Medicaid Asset Preservation Strategies. So the Medicaid program, if you look at that and you've got $1 million, you're going to say, I don't qualify for Medicaid. That's way too much money. And you would be right. But that's not where the analysis ends. Let's dig in deeper. Of their $1 million, 500,000 is in a house. Under Medicaid's rules, that house doesn't count against this couple for Medicaid eligibility because John lives in that house. So out of the $1 million estate, 500,000 goes off the table. That is a non-countable resource. So let's talk about the other 500,000, which counts. That is money in the bank, IRAs, etc. What do we do with that? Well, let's get into the care piece a little bit more. Practically speaking, when somebody moves into an adult family home or assisted living facility, that facility will have what's called a private pay requirement. Not all facilities do. Many good facilities will say, no, we'll take Medicaid right away. Some will say we'll take Medicaid never. Some will say we'll take Medicaid after 2 or 3 years. Some will say a year or 6 months. One of the reasons that you want to be working with an attorney and an aging care manager is that it is advantageous to negotiate for you the shortest private pay period possible. So in this situation, John has found the adult family home that will do memory care. They have a 1-year private pay period, and the cost at this home is $8,000 a month. So doing the math, John is going to need to go through $96,000 to pay for Joan's care for that 1 year, not because of Medicaid, but because the facility requires it before the facility will accept Medicaid. So be aware of that. Medicaid isn't necessarily accepted right away. So you want to be doing planning in advance. That's one of the reasons to seek out an estate planning and elder law attorney years in advance of actually needing care. Why? You want to have the good estate planning and documents in place before somebody loses capacity. Fortunately, John and Joan did that. So even though Joan has dementia now and doesn't have legal capacity, that doesn't mean that John can't take the steps he needs to protect his assets and make sure Joan has good care. And if it sounds like I'm getting into a lot of details with Medicaid Asset Preservation Strategies, I apologize. I am, because it is a very fact detail-oriented process. So that's why I'm giving an example. So let me move on here with this example. And obviously in this case, they don't have long-term care insurance. All they have is their assets. And John's going to have to go through about $100,000 before Medicaid will be accepted by the facility. And that's what he does. So before that 1-year private pay period is up, John is working with his elder law attorney. Now, out of $500,000, which is countable, he's going to take $100,000, pay for the care facility for that 1 year. He has to do that, not because of Medicaid, but because of the care facility. He's got $400,000. And if you ask any attorney, is $400,000, am I eligible for Medicaid? The answer is going to be no, you're not. Don't let the analysis stop there, because we have tools. The secret is that we have tools in place that allow John to keep all of that $400,000, all of that money. How does he do that? In the state of Washington, for this type of care, the state of Washington is going to say, John, you can keep about $60,000. It goes up every year, but I'm just going to use $60,000 as a round number. The ill spouse, the person on Medicaid, she only gets to keep $2,000. But John needs to keep $60,000. He's got $400,000. You're saying, what do we do with that $340,000? Too much money. Medicaid allows John to purchase a Medicaid compliant annuity through which he takes what is a countable resource, his bank account, $340,000 too much. He buys a $340,000 Medicaid compliant annuity in his own name. And in the state of Washington, our rules will say that that is going to pay back to him month after month over a 5-year or 60-month period. So if he puts $340,000 into that annuity, it's going to come back to him every month, $5,667 a month. He will get all of his money back. He did not need to spend down his money. His wife qualifies for Medicaid. He gets to keep all of that $400,000. He simply needed to convert it from one form to another, and the other being the Medicaid compliant annuity, which pays back to him. He gets that money back. He will not be impoverished because he went to an attorney, an elder law attorney, who understood Medicaid's rules and helped him keep all of his money. That is a gem that I want you to keep in mind, that saves hundreds of thousands of dollars, and it makes sure that John, or whomever is the well spouse, will not be left impoverished. I'm going to keep going, even though I think that was one of the most important things that I wanted to convey to you today. I don't want anybody to think that they have to lose their house because they're on Medicaid. A couple should never lose their house. They might lose their house if they don't go to an elder law attorney. Think back to when I was describing what couples typically do, which is spend down their money, spend down their money, spend down their money till they have only that $60,000 left. And then one goes on Medicaid, the other is living in the house. What happens then if they haven't seen an elder law attorney? What happens is at the end of the day, the state is going to get the house, at least to the extent of Medicaid benefits paid for the ill spouse. The state won't enforce that lien until the second spouse dies, but the state will still get the house and not the kids of the couple, which is a terrible result, especially terrible because it could have been 100% avoided through good legal counsel. So recall I said that in our example, John and Joan had good estate planning documents. They had good, effective, durable powers of attorney, and they were smart enough to use an elder law attorney who knew about Medicaid. They are not going to lose their house. Not only are they going to keep all of their money, they're not going to lose their house. How does an elder law attorney protect the house for this couple? Well, it's through that most important legal document, the durable power of attorney. So when Joan had capacity to do so, she signed a good, effective, durable power of attorney, appointing John as her attorney in fact. That means her POA. That means the person that has legal authority to act on her behalf. When Joan goes on Medicaid, what is John going to do with the help of his attorney? He is going to sign a quitclaim deed conveying Joan's interest in their house to John. He does that through the power granted to him in Joan's power of attorney. Without it, Joan can't sign, and we can't convey the house to John, to the well spouse. In addition, to make sure there's no argument that Joan has any property left on her death, we're going to make sure that all bank accounts are in John's name, and we are going to have John sign a separate property agreement where Joan conveys all of her property to John, and she does that through her power of attorney. So John signs on her behalf. Even though Joan lacks capacity, we're able to do this because we have the good, effective, durable power of attorney. As a result, this couple got to keep all of the money that wasn't required to be paid to the facility on that private pay period, and the state gets nothing. And when Joan is on Medicaid, her income only goes to pay Medicaid. None of John's income in the state of Washington will be required to pay for Joan's care, so John is not impoverished. That is so important. That is a secret. It shouldn't be a secret. Please share this information if you know of anybody who might benefit from it. And it is definitely a gem that saves hundreds of thousands of dollars. You can tell I get excited when I'm talking about Medicaid strategies because it is so not well known that it's an area where I feel we can make a big impact in helping people.